afternoon, everybody. I'm Amanda Weston, King's Counsel, and I have the great honour of chairing a very interesting webinar, which is the second part of the Garden Court two-part series on community care update. We've got three brilliant speakers for you today, but before I get on to introduce those, I'd like to tell you three things. The first is that the webinar is being recorded. The second is that we'll be sending the slides out afterwards. And the third is to ask you, if you do have questions, to use the Q&A facility in the webinar and not the chat, as it helps us keep track of questions for the end. Now, the first of our speakers today is Conor Johnston. He's going to be speaking to you today about the adult social care. And I'm just clicking up Conor's bio. So Conor is one of the conveners of the Garden Court Community Care Team. I don't think that gives him justice. He's actually a prime mover of the team and the essential driving force behind the team. A significant element of his practice is focused on asylum support, including adequacy and dispersal challenges. And he has been also a volunteer advocate with ASAP at the Asylum Support Tribunal for the last 5 years. So lots of experience behind what Conor's going to speak about today. He's going to speak to you for about 15 minutes. Take it away, Conor.
Sorry about that, Amanda, just a few tech issues. So I'm actually going to be dealing with asylum support today. So if you'll bear with me a moment, I'm just going to share my screen. If Amanda, perhaps you could let me know if and when this is working.
I can see the screens. Absolutely. Right. You've now got it on slideshow, which is great.
Thank you. So what I'm going to be talking about today, folks, is the developments in asylum support over the last year. I'm using that term asylum support generally to encompass Section 95, Section 4, Schedule 10, really everything that you can get from the Home Office. And what I want to look at specifically is changes in who can get support, what support you get, and how you go about getting that support. What I'll say at the beginning is I'm going to be focusing on the headline points of the big important things that I think have changed in the last year. So in particular, there are consequential changes, minor changes, such as a plethora of updates to Home Office policies in this area. And I'm not going to mention every single one. I'm just going to mention those that I think are significant. So dealing with the first topic then, who can get it? So what I mean by that is the eligibility criteria. Now, I'm going to assume that everybody who's here who's interested in asylum support has a base level of knowledge in this, but just the briefest of refresher on who can get it. Section 95 is for destitute asylum seekers. Its counterpart for former asylum seekers, failed asylum seekers, is Section 4. If they're destitute and they're facing a barrier to removal to their country of origin, then they're going to be eligible. We then got that supplemented by para 9.2 of Schedule 10 of the Immigration Act, which is for those who aren't eligible for Section 4 or Section 95, but are on immigration bail. There is this residual type of support which is available in exceptional circumstances, which includes circumstances where somebody's facing destitution and breach of their human rights and cannot return to their country of origin for whatever reason. So between Section 95, Section 4 and Schedule 10, that covers most people who might be seeking support from the Home Office. But also in addition, we've got this rather woolly, loosely defined power which the Home Office says exists, which is under the royal prerogative to provide support in other circumstances. And that was a concession that was made in one of the big asylum support challenges from the previous year. So I'll come back to that because it is relevant in due course. In terms of the eligibility criteria, then, they don't generally change that much year to year, but actually in 2022, we have seen quite a significant change, which is to the definition of who is an asylum seeker and who is a failed asylum seeker. So we've got amendments to both Section 4 and Section 94, which relate to the introduction of the new inadmissibility criteria. So those whose refugee convention claims are declared as inadmissible because they have a connection to a safe third state, those who receive such declarations, it will impact on their eligibility for support. So specifically, once you get a declaration, you are no longer classed as an asylum seeker for support purposes. So you fall out of Section 95, but you are classed as somebody whose claim has been rejected for the purposes of Section 4. So you come within Section 4. So these changes are introduced, all part of the package of changes introduced under the 2022 Nationality and Borders Act. And more specifically, they operate at the moment in conjunction with the Rwanda scheme, because the fact that you have a connection to a safe third state doesn't necessarily mean you will be removed to that state. It could be that you are removed to another safe state, and that state, in the eyes of the Home Office, is Rwanda. So the current intention behind all of this is it's a way of affecting the eligibility for support of those who are going to be removed to Rwanda if that ever happens. It's still pretty early days, although this has been enforced for about 6 months. So it's difficult to say exactly what problems that you as practitioners are going to be facing and dealing with. What I would say, just as a caveat, is that I've given you the broadest overview of this. It's very detailed. Who does this apply to and when? So as well as the statutory provisions I've referred to, you want to be looking at the various guidance that the Home Office has updated and published in the last year on the subject to work out exactly whether your client is affected by this or not. But just a few practical points that I think may give rise to possible challenges, issues. First, this operates from the point of declaration, not service of notice of intent. So somebody will normally get a notice of intent that they are going to have their claim declared inadmissible. That doesn't affect their eligibility. It's only when the declaration is made that they're no longer eligible for Section 95. So I can envision the Home Office making mistakes there and terminating support early. At that point, if you get the declaration, the onus is on the applicant to apply for Section 4 support. It does not happen automatically. So practitioners need to be aware, if your client gets one of these, the client needs to be proactive about getting support, making an application. It's not just going to happen. And then if there is, once the declaration has been made, it's not necessarily the end of the story. Secretary of State can decide to revisit the asylum claim if it becomes clear, for example, that the person is not going to be removed within a reasonable timescale. At that point, they become an asylum seeker again for support purposes, and they should be automatically transitioned back to Section 95. So that's another, I think, probable practical issue. I would be very surprised if that actually happens, and you may need to be chasing that to ensure your client gets continuity of support. And then finally, Home Office policy doesn't currently recognise that somebody who is seeking to challenge the inadmissibility decision is facing a barrier to removal. And so therefore, combined with the fact that they are a failed asylum seeker, that should give rise to Section 4 eligibility. But the policy is not exhaustive. I imagine you will get some negative Home Office decisions saying, oh, you can just leave the country, you're not entitled to Section 4. The Asylum Support Tribunal, I think, is going to have no problem in accepting that that is a barrier and that somebody should be supported in that context. So the only other point I wanted to raise on eligibility relates to a point that actually Tessa picked up. If those of you who were at yesterday's lunchtime webinar where Tessa Buchanan spoke about Children Act support will have noted what she said, and no doubt you'll have been aware of anyway, the scandal that we're seeing at the moment where we've got large amounts of children, undisputed children, who are being put in hotels by the Home Office and are going missing, and they are being trafficked. And to me, this is, quite astonishing in the context of asylum support, because I cannot fathom what power it is that the Home Office purports to be acting under. We have a statutory definition of an asylum seeker which excludes those who are under 18. So that means it can't be section 95. By extension, it can't be section 4, because failed asylum seekers, you can't be a failed asylum seeker if you've never been an asylum seeker. It can't be schedule 10 because the policy specifically says that's not available if you've got other forms of support like the Children Act, which is where these kids should be being accommodated. And I can't see that it's possibly the royal prerogative, which is a residual power of the Crown. It's a historical anachronism. It is not available in cases that are well trodden by statute. So to me, that the Home Office is doing this at all is astonishing for many reasons, but not least of which because I can't see what power they're using. So that's who can get it. In terms of what you can get, quick refresher, you can get accommodation and you can get essential living needs. So that is roof over your head and money week to week. Now that roof over your head should be adequate. The statute says that. And what adequate means, among other things, is it should ensure a standard of living adequate for the health of the applicant. So that's the reception directive, which still applies in this context, Brexit notwithstanding, because we were told so by the High Court in the Napier case. So any accommodation which is undermining your client's health is not going to be adequate on that definition. So that's just refresher. We've had a few what I'll call general adequacy cases over the last year and a bit. So I've cited 2 of them. Apart from ALW, which is interesting because it raises Equality Act issues, these cases aren't really breaking new legal ground, but it is useful to have them in mind if you're making an adequacy challenge in the High Court, just because it's always useful to know how the High Court is approaching these cases. So one negative case is AMA. That was a hotel case, not unlawful to accommodate the applicant and son in a cramped shared hotel room, which made it very difficult for them to access the kid's school and the hospital that the mum needed. So that's obviously a sort of low watermark in the last year and a bit. And then the ALW case, which I've already referred to, where there were Equality Act issues. In that case, actually, inadequacy was conceded by the Secretary of State, and it was about whether or not that meant what should happen as a consequence, whether the Secretary of State was failing to discharge duties in finding alternative accommodation. That case involved a household with severely disabled child with a need for a wheelchair. But that's sort of general broad brush principles and generalist cases, but more specifically, what are you going to get in terms of accommodation? Well, more than likely at the moment, you are going to get a hotel. Your client is going to get a hotel. This is a hangover of the pandemic. We've still got huge numbers, 37,000 back in November, according to the BDBC, who were in hotel accommodation. So huge numbers. This is getting worse and not better. I think that what that means from the point of view of those of us who want to get our clients out of hotels is it's not going to be enough, if it ever was, to say my client's in a hotel. That's not good enough. You need something more. You need to, I think, either focus on detriment to health, which is the reception directive standard. You need perhaps to focus on Equality Act challenges, i.e. failure to make reasonable adjustments or indirect discrimination by applying a PCP of putting a disabled person in a hotel when it's just not appropriate. So ALW gives you a bit of a template for Equality Act challenges in this context. Or you need to focus on the detriment to the children's welfare, which is well-trodden ground in homelessness, and you'll see that in cases like Nzola Mazo. But we also, I think, need to start thinking a bit more about the planning issues which arise from the change of use or the potential change of use from hotels to hostels. And there's been a number of really interesting cases where the High Court's considered interim injunctions sought by local authorities to stop the Home Office putting people in their areas in hotels. So we've got the Ipswich case where interim injunction was refused. We've got the Great Yarmouth case where it was interim injunction was granted. We need to watch those cases to see what happens at the final hearing, to look at the underlying legality of just putting asylum seekers in hotels in local authority areas. But then there's also the Howe case, which is a different planning type challenge, where actually the challenge there was to a planning permission contained in a statutory instrument made by the Secretary of State, and it was an individual person who brought that challenge in relation to the grant of planning permission for Napier, the extension of planning permission for Napier, and that decision to do that was held to be unlawful for failure to consider the equality impacts, for example, the racist abuse and tensions that could arise from use of facilities in areas. Because we have so many hotels, we are seeing, or we will be seeing in future, the use of more accommodation centres. That was in the new plan for immigration. And we've got an existing framework in the 2002 Nationality Act, which has been amended by the 22 Nationality and Borders Act. The bits of the 2002 Act are not yet in force, but and so at the moment, what that means is that the regulatory framework for accommodation centres is pretty loose. And although the Home Office will say, well, we don't have any accommodation centres, we know that they have things that are centres in all but name. So things like Napier, they might say it's not an accommodation centre, but it looks and smells like one. And as I say, the regulatory framework for that sort of accommodation is not particularly well defined at the moment. But what we do have, moving on to the last bullet point on the slide, is guidance on the use of dormitory type accommodation, which includes Napier, but any other accommodation with shared sleeping quarters. So this would apply to accommodation centres or quasi accommodation centres. And I think the important thing to flag here is that the guidance in effect excludes most categories of vulnerable people from this sort of shared accommodation. It excludes those with serious mental health problems facing suicide risk, it excludes those with disabilities. And actually that encompasses a huge number of our asylum seeking clients. So there's a good argument that really most people should not be placed in this kind of shared accommodation. What do you get? I focused on accommodation so far. Support rates, we've had some interesting cases on how much money you should get each week over the last year. So JM and AXG both dealt with the basket of goods based on which the weekly amount of support is calculated. So it's meant to pay for things like travel and non-prescription medication, communications costs. Those we know from these cases and early ones are essential living needs. There's a specific amount of money allocated for each. And if your client for any reason is getting a reduced amount of payment, they're not getting the full amount that's normally given, then you want to look at these cases, take instructions from your client, find out what of their needs are not being met in the accommodation, and then work out your sort of a calculation of what they should be getting based on that. So if their communication needs aren't being met, if they're not getting money for that, then that is what you want to be asking the Home Office for. Then we've got CB, case just before Christmas, Greater Manchester Law Centre, really interesting case, looking at the effect of inflation on these rates, which have been pretty miserable for quite some time, and a mandatory order in that case saying the rates needed to be increased to £45. I'm coming to the end of my time, so I'll just quickly move through my last couple of points. Firstly, that the CB case and uprating for inflation, we're already seeing the wider application of that in other contexts. In the recent case of BCD, Birmingham Children's Trust, where looking at, among other things, the importance of considering inflation in context of rates of support under Section 17. So think about how you might transpose these arguments to other contexts. And then finally, on process, how do you get it? I really just wanted to flag the ongoing problem of delay in getting asylum support accommodation. And I'm not going to go through it now for lack of time. Feel free to ask at the end. But I think there is an interesting continuing debate about actually what is the nature of this duty under Section 95 to provide accommodation, to provide adequate accommodation? Is it a duty to take reasonable steps to do it, or is it a duty to provide it immediately? And that's something I think needs some resolution. So I'll finish it up there and hand back to Amanda.
Thank you very much, Connor. That was very detailed and thought-provoking, especially about the missing children. I wonder where that litigation is going to head. Anyway, so our next speaker is Adrian Berry. He's a very senior public law practitioner in Chambers, and he has a broad public law practice. You might have come across Adrian in the context of his specialist immigration and nationality work, for which he's a great authority, but he also has a great deal of specialism in welfare benefits, particularly sort of the retained law aspects of EU related benefits. And he's got a developing practice in education also, with which he brings his broad public law expertise. So take it away, Adrian.
Thank you very much. So I'm going to look at just four recent cases. And the reason we're going to look at these isn't just for what they say and their answers, but what they remind us that we need to be concerned about when we're thinking about challenges. First of all, we have the sorts of things that we might be thinking about when we look at decisions or omissions or challenging policies are obviously the sorts of things which are amenable to judicial review in the context of the things which adults with social care needs are concerned, but also things to do with Human Rights Act compliance and also to do with Equality Act challenges. And so what I want to show is to illustrate today from these recent cases some points which are not answers in themselves, but allow us to organize our thoughts when we think about what sorts of issues we can challenge when we look at decisions relating to people with care needs, not just in the context of the Care Act, but the broader range of issues which such people have in their lives, such as access to cash benefits or their lawful status and so on. And so this is really just a quick way of touring through and a reminder of the points that we ought to be considering when we consider formulating letters before claim, because often by the time cases are up and running, sometimes it's too late to put things to local authorities or to central government departments in judicial review grounds. And so what we like to do is to work collaboratively and to try and frame arguments at the outset. And so this is really just a quick way of looking at that. The first case is very recent, from the 17th of January, T against the Secretary of State for Work and Pensions. And the issue in that case was whether or not, in relation to a cash benefit, whether or not a universal credit had been uplifted during the pandemic, but there had been no corresponding uplift for elements for the personal allowance elements of benefits predating universal credit, so income support, job seekers allowance, and employment and support allowance. And the issue in that case was concerned the question of the approach to Article 14 of the Convention on Human Rights in the context of public policy choices. So this is a good example of a case where the judge has to decide something for herself or for himself, and there's public policy issues alive, and there's a question of Human Rights Act compliance. So it's not strictly a sort of question, if you like, of just judicial review principles in the ordinary sense, but the question of compatibility and whether or not there's been a violation of convention rights under the Human Rights Act. And in that context, at first instance, Mr. Justice Swift held that there was indirect discrimination because the measure had a disproportionate impact on disabled people. But he found that the difference in treatment was justified. And then he found that, and the question really was whether, in assessing the Secretary of State's actions, whether this was just in terms of whether it was justified, whether or not he erred in his Article 14 assessment, in part by assessing justification and proportionality only at the time that the regulations were enacted and not by reference to the facts and evidence at the time of the proceedings below. So this raises another question for us. When you're looking at the compatibility for Human Rights Act purposes of regulations, are you looking at them at the time they're made or at the time they have this impact on the person who's bringing the claim? Because of course, sometimes you're bringing a challenge sort of a long time after regulations are enacted, and you're bringing that challenge because it matters to you. And so for the issue in that case was whether or not the factual premise in the case was whether or not the number of disabled people in receipt of legacy benefits, employment and support allowance, income support, and so on, as whether that as a proportion of people still receiving those benefits was greater than the number of disabled people receiving universal credit as a proportion of the total number of universal credit claimants. So he said that there was some indirect discrimination here, and that disability was an issue, and therefore that was a suspect ground for the purposes of the standard of review, and clear justification was required. And then he takes us through this test about what intensity of review there ought to be, which you see in the case of SC. And he found that there was justification in the context of privileging uprating for universal credit, but not for legacy benefits. And so the appellants challenged this in the Court of Appeal on the basis that he had erred in his approach, really, by looking at the regulations for the purposes of assessing justification at the time they were made, rather than latterly in terms of their impact on the group of people who were the complainants in the case. And they brought their challenge essentially that there was an ongoing failure by the Secretary of State to remedy the difference in treatment. And so you can see there the template for Article 14 assessments. And the question there was whether the judge's conclusion was an objective, that whether the judge's conclusion that there is an objective and reasonable justification is correct. And that's a value judgment to be made by the court. And then in the end, that issue cut across the fact that there is a certain amount of, if you like, a tolerance given to the executive when it comes to making complex social and political judgments involving difficult social and economic choices. And so when the Court of Appeal came to look at it, they said, well, looking at what was happening, that universal credit was uprated for particular reasons that did that, and for reasons of efficiency in terms of, and flexibility in terms of how universal credit works as compared to those legacy benefits such as income support and employment support allowance. That judgment of the Secretary of State for Work and Pensions was correct. And as far as this question about the role of the court in looking at the compatibility of the regulations in terms of the persons upon whom they are now biting, are the regulations to be justified in terms of their impact on people now? The court concluded that where there's a demonstrable and material change in circumstances that shows that the measure is no longer rationally connected to a legitimate objective, or its impact is significantly different, those are plainly matters that a reviewing court should take into account, but it didn't apply on the facts of this case. So the nutshell from that is, if you're thinking about bringing an Article 14 challenge to regulations, always bear in mind this argument is available to you in terms of the, if you like, the human rights compatibility for when you're bringing your challenge, but you may not, you have to consider whether you can show that the impact as at today's date upon you. And so you can take the regulations as they're made and you can challenge them in terms of their whether or not they're rationally connected now. But bear in mind that that assessment may not favour you, and it's worth reading this judgment carefully because it illustrates the approach to be taken to that. The second case we're going to look at is from the Supreme Court, but from Scotland, and it concerns the effect of the Equality Act in relation to the provision of community care services to disabled persons under the Social Work Scotland Act, and it deals with the two bases on which disabled persons may challenge charging for care. So that's again an important issue. The appellant acted as guardian for her son, who was an adult, and his disability resulted in him being provided with community care services by the local authority. In the case, and it's important to note that the council didn't contend that there was any irrationality or there was any other like unlawfulness according to the usual general obligations arising under public law. And so the point was purely taken in reference to the Equality Act, which, as we know, protects disability and those who have the protected characteristic of disability. And the challenge was by reference to Section 29 of the Equality Act and the provision of services and the performance of a public function. There were two bases on which it was argued. Section 15 of the Equality Act, discrimination arising from a disability, and Section 20 in terms of the duty to make reasonable adjustments. And the appellant submitted that there ought to have been greater deductions made from his, if you like, from the money available to him for disability related expenditure, so that in effect he would receive more support from the local authority because his own income, it wasn't as great as claimed because certain deductions ought to be made, and that the failure to make those deductions from his expenses was discrimination arising out of his disability. But the way in which the court approached it was to look at this issue in a different way and to say that in essence that the adjustments that the assessment that the local authority had made in a sense favoured him, and that favourable treatment for him was already built into its approach. and say the fact that he wanted to claim other things that were disability related expenditure didn't mean that he was being discriminated against. In fact, properly analysed according to the court, he was privileged. And so that there's a bit of a trap here, and this is why this case is worth reading carefully as well, because you think you might have a difference in treatment. You think there's some things which, properly analysed, ought to be taken into account for the purposes of whether the amount that you'll be charged. But you have to tread very carefully, and you'll see there at the bottom bullet point, the council had adopted a practice according to which items are rejected if they don't relate to a disability, or a person receives a benefit to meet the cost, or if they represent discretionary spending. And the view of the Supreme Court in that respect was that that the council's policy was lawful. It only relates to disabled people, so there isn't a comparison to be made with persons who are not disabled. And in fact, as I identified, it confers an advantage. So in respect of discrimination arising from a disability, it's a very useful case in that respect. Sorry, and also the duty to make adjustments. Sorry, these slides have gone slightly astray. And in terms of the duty to make adjustments, they took a similar view in terms of, so the two issues, both discrimination arising from a disability and also the duty to make adjustments, there was a lawful decision reached. And so what the case is useful for is if you want a sort of laboratory test or a sort of example of how the Equality Act relates to a Care Act issue, you'll find it here. And you'll find that the choices made were to look at those two, not to a challenge based on direct discrimination or indirect discrimination, but the other two bases upon which disability claims can be made: discrimination arising from a disability and the duty to make reasonable adjustments. The next case, just to mention briefly, is the Independent Monitoring Authority case on citizens' rights. It's a withdrawal agreement point about whether or not you have to have lawful, about the circumstances in which you're lawfully resident. People who have Brexit withdrawal agreement rights did they need to maintain and reapply for residence permits at the end of their 5 years of having limited leave to remain, and if they didn't, would they be unlawfully present? And this matters, of course, because lawful presence tests are littered throughout community care obligations, and the question of lawful presence is a continuing issue for people who are not British citizens or Irish citizens. And so the Home Office practice is essentially just to grant limited leave to remain pre-settled status for 5 years, and then you're obliged to apply for indefinite leave to remain thereafter. The question of whether that was actually compatible to with the withdrawal agreement was raised, because it could leave people being overstayers if they failed to reapply. The court considered that a person who has limited rights, limited rights under the withdrawal agreement, and who continues to satisfy those conditions, cannot lose that right. So notwithstanding the requirement for documentation, and that those rights which are granted by reference to the need to secure a resident status include the right to reside permanently once the 5-year period has been satisfied. So it's up now to the Home Office to decide how they're going to adjust the EU settlement scheme, or appeal potentially, obviously, in order to comply with that. It's very useful because the underlying rights subsist. You can have your documentation scheme if you want, if you're the Home Office, but you're going to have to make sure it complies with the rights which arise under the withdrawal agreement. You don't have a free hand, is the message to the Home Office from this case. And it's very useful for assessing whether or not a person is lawfully resident, and may have some interesting impacts in terms of Schedule 3 of the Nationality, Immigration and Asylum Act 2002. Final case is Case against the Secretary of State for Work and Pensions, and this is about the routes to which achieving universal credit if you are a disabled person and you either and you wish to study. There are two routes to this. You are already in receipt of universal credit, and then you want to drop into full-time study. There's a regulation exception that allows you to maintain your universal credit in those circumstances. But if you come through from school into full-time education, you don't have that option. And so the question is that difference in treatment, if you like, between classes of disabled persons? Is it lawful? There are 4 points in the case. One, there is no duty to consult on the Secretary of State to consult in making amending regulations, either at common law or by statute. 2, there wasn't, having regard to its purpose, any irrationality in the Secretary of State's approach. And a third point, which is of a particular interest for the purposes of this. And so on the second point, on the irrationality point, it doesn't matter that the universal credit regulations were amended, but other regulations were not in respect of employment and support allowance. So you can't just argue that by reference to policy choices which are made in respect to specific benefits, it can be difficult to sustain the argument that because you've adjusted one, you must adjust others. And there's an interesting argument, though, that there was no claim brought under Article 14 of the Convention on Human Rights, but nonetheless an argument that a principle of public law could be deployed, that it may be unlawful by virtue of the operation of a rule on a partial or unequal basis. In other words, discrimination in the rule, not by reference to Article 14 of the Human Rights, the Convention on Human Rights, but by reference to administrative law principles. That point was deployed. Against that was pitched the argument that a high level of respect should be given to the decisions of government in the field of social and economic policy. The decision to discriminate in terms of the difference in the regime in terms of how you get into whether or not you're entitled to universal credit if you come straight through full-time from school into full-time education. The use of the public law principle that discrimination, the idea that discrimination may arise as a matter of public law was rejected by the court in that case, and they said in any event there would still be justification in the use of the public law principle of discrimination, if you like, even if it had applied. And then finally illustrated the nature that we're familiar with, but it's a constant refrain. If you bring up a challenge in respect of Section 149 of the Equality Act and the public sector equality duty, this obligation to have due regard is, of course, not to a duty to have regard to certain matters, but not to a particular outcome. You shouldn't undertake a forensic analysis of inequality impact assessments, and that often this point, which is often taken, is often quite hard to sustain in practice, and you have to be very careful about that. It's often an argument which is thrown in as sort of ground 3 or 4 in cases, and it rarely is sustained once they've had a look at the matters and a policy decision has been made. It can be hard to get home on it. So thank you very much. Thank you.
Thank you very much, Adrian. I think that everyone would agree that that is an exemplar of an area of law welfare benefits where the value of getting counsel in at the earliest stage in order to frame your challenge in the pre-action protocol process is paramount. Well, thank you very much. And now we're going to move on to Bethan Harris. Bethan obviously has been practicing in community care law, including specifically and in particular adult social care for very many years. And I think it's fair to say that what Bethan doesn't know about adult social care probably isn't worth knowing. But she's also, we remember, editor of the community care law reports. And she's going to speak to you today about the Care Act and some case law updates on adult social care. Thank you very much, Bethan.
Thank you. And thank you very much for that introduction. And there we go. I think I'm there with my slides. I hope I am. Not quite. Right. Excuse me. Okay. Now, does that work? Ah, that might be it.
That's great, Bethan.
Yep. Okay, great. Thank you very much. Okay, so in the remaining time, but hopefully still leaving a little bit of time for any questions or comments at the end, this is an overview really focusing on case law. And these are the cases I'm going to look at: contempt proceedings against public authorities, costs of holiday being claimed as care and support, unlawful decision-making relating to care and support plans, the Care Act, Housing Act interface, an unlawful policy relating to disabilities facilities grants, DFGs, briefly at some other important cases in the field of adult social care, and then at a very important report that the House of Lords Committee on Adult Social Care brought out in December. So first of all, with regards to contempt proceedings being brought against the public authority, this is a case which concerned the Social Services and Wellbeing Wales Act, where services were being sought, and it concerned the failure to do the care planning, to produce, to finalise the care planning for a young person who had autism and therefore had needs for care and support. There was a first judicial review. Local authority failed to comply with a consent order which was drawn up to conclude that judicial review. Second judicial review proceedings were brought. The court made a mandatory order, which obviously courts don't that often make mandatory orders, but obviously was already a bit of a history of non-compliance. Later granted an extension of time of that order and provided that a senior person, the Director of Social Services, would need to come forward if there was a breach. There was a breach. Contempt proceedings were commenced. The court entertaining those proceedings sets out usefully the process for bringing contempt proceedings against a public authority. So the case is very useful from that point of view. And then and coming to the conclusion that there was a contempt, which there clearly was, it was noted that it would have been open to the local authority to apply to vary the order rather than simply just to not do what was required. And it hadn't done that. Also, it hadn't called a senior officer to come and provide an explanation. The local authority's submissions were that it was in doubt as to whether it was in breach, but clearly there was a serious dispute, at least, as to whether it was in breach, and it was found to be in breach. And so it was wrong of it to sit back and not bring forward a senior officer to file any evidence in the case. On making a finding of contempt, it was found that the penalty for that was essentially the public humiliation of the public judgment, but the court was nevertheless open potentially to making a further penalty applicable. That would depend on what the local authority did next. Moving on to the next case, this is a Court of Appeal decision, and it concerns the matter of whether provision of a holiday or paying for a holiday is care and support under Section 18 or potentially Section 19 of the Care Act 2014. And the local authority in this case had in fact been paying for holidays for this particular family. And when you look at their circumstances, you can see why that was appropriate expenditure, because the mother looked after two adult sons who had autism, learning disabilities and other conditions. Due to past experiences, it wasn't feasible for them to be looked after in any other context. And part of the care package was respite for the whole holiday, for the whole family to go to Florida, which had a beneficial impact on their mental health and on the whole ability of SQ to as a primary carer. Not that she wouldn't, of course, been able to afford that, to pay for it herself. So this was obviously a mother providing an awful lot of care that, you know, it often, of course, needs to be provided by and paid for by social services. So the question was whether the local authority was right to reverse its decision that to pay for these holidays was something that could be provided under Section 18 as a Care Act care and support service. And the judgment, first of all, I flag at paragraph 65, it sets out a useful explanation of the sequential approach that local authorities should take to assessment and care planning. That might be a fairly obvious thing, but it is just, I think, useful to remember and to have it spelt out by the Court of Appeal, that that's the approach, that when you're looking at decision-making by local authorities under the Care Act, you need to look at it through the prism of the framework in the Act, and where there is what was here and is sometimes the case, some muddled decision making, you know, doggedly plough through the framework of the Act, and paragraph 65 gives us the sequence. Then the Court of Appeal went on to consider the context in which it was looking at the issue in the case, and referred really helpfully to the wellbeing duty. and that the purpose of this provision is to help individuals to achieve outcomes which is important to them in life, into the life that they lead. And then went on to address the phrase looked after needs, which is a phrase which comes from the case law prior to the Care Act coming into force, and distinguished, distinguished the Care Act provisions from that concept of looked after needs, and stating that care and support is wider, and that one has to look at the individual nature of the assessment, the recognition of autonomy of the individual, and the broad nature of the support that can be provided. And this, of course, is an essential part of what the Care Act is all about. And it's very good to see the court bringing that out, that, you know, the Care Act is obviously has underlying it the wellbeing duty in Section 1. It went on to hold that recreational activities and holidays, they can be relevant to eligibility criteria. G and I, personal relationships, making use of facilities in the community, recreational facilities which are not geographically confined. And in the case of B and G, their needs, they did have needs in relation to these particular areas arising from their physical and mental impairments, and went on to hold that as a matter of law, there is power under Section 18 and potentially Section 19, of course, to provide this as a service under the Care Act. So it's not just providing the care for a person when they go on holiday, it's providing for the actual holiday itself. That's the distinction. Obviously, that doesn't mean that everybody is going to get their holidays paid for who's eligible for care and support under the Care Act, but it does mean that in an appropriate case, that may be the appropriate care and support for for an individual. Turning now to the case of P against Croydon. This is a case concerning decision-making in relation to a care and support plan. This concerns a person whose care and support was initially set out as being a care package to the value of £1,200 per week. That was the essential component of the care and support plan. The local authority later decided to change it to 35 hours a week. That was following a meeting of its funding panel. When the family of P sought to have the original care plan put in place, the local authority responded by offering a reassessment of P's needs. But the family, on behalf of P, refused a reassessment because P's needs hadn't changed. It was the care and support plan which had been changed by the local authority. And the decision-making of the local authority was challenged. It was found that the decision to switch to 35 hours a week was unlawful, whereas of course where a local authority has stated an indicative budget, which is what the £1,200 was in the initial statement of care and support, that was an indicative budget. Of course, the local authority could not adopt its indicative budget, but of course it had to do so in the right way, and that had to be procedurally fair, reasoned and reasonable, not just producing another decision essentially coming from nowhere after a hearing of its funding panel. The local authority's offer of a reassessment, of course, didn't hit the spot because this wasn't about reassessment, it was about care planning. And the decision on the second care and support plan was also in breach of the statutory guidance. And in this case too, the court refers to some of the basic principles that inform the Care Act, stating there, as I've highlighted, this is legislation concerned not just with the consequentialist objective of promoting the physical and mental health and emotional well-being of persons who have relevant needs. It also reflects Parliament's concern to give them the kind of autonomy that is associated with their being able to exercise control of their day-to-day life. And that was said in the context of the importance of the principle that care and support plans are drawn up in consultation with the service user and other people like the family here who are involved with their welfare. There's also a useful reminder in this case of the high threshold that there is under Section 31 of the Senior Courts Act for public bodies to avoid relief being granted on the basis of seeking to argue that the outcome would have been the same anyway. It's a high threshold. Final point in relation to this important case is that there was also a claim for a declaration as to the unlawfulness of a past failure to deliver care that P had been assessed as entitled to. And that was a clear point of breach, really not requiring any particular adjudication. The facts were agreed. It was clear that what should have been provided hadn't been provided, and that was recognised by a declaration that was made in this judicial review. I think as far as the comments are concerned, I think I've mentioned all those points. There's one in there, which is the reference to the importance of the care and support statutory guidance and the principle in XP Rixson, that there is quite a strong requirement to comply with statutory guidance unless there's a good reason not to comply. So it's useful in reiterating that principle as well. So moving on then to Campbell against Ealing. This is a case in the important area of the interplay between the Care Act and the Housing Act 1996. And this concerned a situation where the person concerned had temporary accommodation had been paid for by social services for quite some time, not just for a short-term temporary period of transition or in a crisis, but although it may have been that initially, but actually for quite a long ongoing period. And this wasn't a person who wasn't entitled to normal social security support, wasn't a person who lacked mental capacity so that they couldn't have access to Housing Act 1996. The judgment confirms principles that we already had in existing case law. A standalone need for accommodation is not a need for care and support. However, local authorities do have power to provide accommodation under the Act in circumstances, that's the Care Act, in circumstances where accommodation is required to effectively deliver care and support. That's a very important principle. But this is, of course, subject to Section 23 of the Act. And Section 23, which I do have on the next slide, but as to the effect of Section 23, and it's about the interplay with the Housing Act 1996, the case that was referred to is the case of Idolo and Bromley, which states that you can't essentially shortcut the detailed system of the balanced priorities in the Housing Act, where there are priorities set out in the scheme of that Act, where those Housing Act duties are engaged. And in the circumstances of this case, that if Section 23 applied, therefore, it would mean that there wouldn't be a power or a duty to fund the accommodation. So the question was, did Section 23 apply? And the situation of C specifically was looked at. And really, I think it's important to note that the decision, therefore, doesn't go broader than that in telling us about the scope of Section 23, but it tells us where someone's in C's situation, where they're plainly a qualifying person under the Housing Act, were able to get offers and was getting offers under the Housing Act, under the allocation scheme, and it appeared would have rights under Part 7, the homelessness duties, that this was a person who was caught by Section 23. And then two further important points here is where there is withdrawal of accommodation, where someone's in receipt of care and support under the Care Act 2014, as C was in this case, then there should be a assessment of needs where a person's accommodation is to be withdrawn. So that's a kind of mitigating point. And also that it is part of care and support services to provide information, advice and advocacy in attempts to find accommodation under the Housing Act as a solution. So I think, again, in terms of the comments, I think I've probably made the comments. Yes, I think that's right. And you'll see there's Section 23. A local authority may not meet needs under Section 18 to 20 by doing anything which it or another local authority is required to do under the Housing Act 1996. Whether that's the case in respect of any individual, obviously you need to look at the facts of that particular case. Then I have very little time left, so I'm going to be very brief on this one. This case is to do with disabilities facilities grants. The person concerned wish to put in a second stair lift, a stair lift as to supplement a through lift, because the through lift tended to break down, and the local authority had a policy not to provide the same sort of adaptation twice by way of a contingency. And the court held that that was not a lawful policy, because you couldn't really just rule out a certain type of response to a need that wouldn't be consistent with the policy of the Act, and that ultimately as far as cost is concerned, it's the £30,000 cap which puts the lid on matters from a cost point of view. Otherwise, one has to doggedly apply Section 23 of the Act, Section 24 of the Act, and that's how you get to the conclusion whether a disability facilities grant, which is of course a mandatory grant, should be provided for. So I think that's all I've got time to say for. And then I wanted to highlight this guidance, the new Disabilities Facilities Grant Guidance, which came out in March 2022. It contains best practice. It sort of states the law, but it's obviously one always has to go to the statute to find the law. But where it's useful particularly is in highlighting a personalised approach to disabilities facilities grants decision making, the use of adaptations in relation to behaviour that challenges and neurodiversity issues, the use of assistive technology by way of adaptations, and also the need to take into account future needs. So it's very modern and really has in it a lot of ideas about adaptations and a lot of really good principles about consultation with families and, as I say, a personalised approach. A few other cases, I'll just pick out Gardiner, obviously a very important case identifying the unlawfulness of a policy of discharge of people into care homes from hospital during COVID, and the irrationality in failure to take into account the risk of asymptomatic transmission of COVID. As you know, of course, we have more of these sorts of issues hopefully being highlighted and scrutinised in the COVID-19 inquiry, which is about to commence in spring. And then finally, my final point is a report which was brought out in December by the House of Lords Select Committee on Adult Social Care, really about the failure to deliver properly under the Care Act, the need for there to be proper paying conditions for people who work in social care, a commissioner for care and support, the full implementation of the principles of the Act, and for there to be working together with local authorities to ensure that the Act is fully implemented. So that's obviously very important and very welcome report. That's everything for me. Thank you very much. I'll stop sharing.
That's amazing, Bethan. Thank you so much. That was really, really detailed and helpful. And we've got two questions. The first of which is from Mary Bennett, and she asks, does the phrasing in Section 23 of the Care Act mean it is a power, not a duty? That is to say, it may not meet accommodation needs that another local authority is obliged to meet. So who would like to address that question? Bethan, Care Act is usually your home area. I'm wondering, would you like to address that one?
Yes, so I think I may not be addressing it particularly well, but the point I think perhaps that comes out for me is the question of when is it something that is required to be addressed under the Housing Act, and what the cases so far don't tell us, and I don't think any case will ever tell us, is some sort of broad kind of definition or formula as to which cases are caught by Section 23 and which cases aren't. So essentially, obviously local authorities can provide ordinary accommodation as part of care and support, and I think that's really brought out by recent case law, particularly the Court of Appeal decision, that care and support is a really wide concept. There isn't really any limit on it, so that we do know that accommodation per se so far has not been regarded as care and support. but accommodation, ordinary accommodation, can be provided as part of care and support in order to deliver care and support. But if Section 23 kicks in, then it means that the person has to look to the Housing Act. But the question is, when does the Housing Act kick in? Because the Housing Act is not a solution for everybody. We know it's not a solution for people who have immigration status, which means that they're outside that system. We know that it's not a solution for people who lack mental capacity, who are not going to be able to make their application. And it may not be really a solution for other people. And what's that? What's that grouping? I don't think we really know yet. All we know is those people who've got, whose cases have been through the courts, we can see, well, they're people who are caught by Section 23. So I'd say Section 23 is not so much a discretion, but it requires looking at the individual case as to whether they're caught by it, basically. I think that's right. And I hope that's some help.
Thank you very much, Bethan. It's immensely helpful. And I'm wondering whether, Connor, you'd like to deal with the next question, which is, would the local authority be able to provide emergency B&B or hotel as a response to a safeguarding duty under Section 42 if there are no other care and support needs to meet? I'm
happy to deal with it. I think probably not. And the reason I say that is because Section 42 is the duty to make inquiries into the concerns about the welfare of this person. It doesn't create a freestanding duty to provide services. It looks to other provisions. It's saying, like, if you are concerned about this, then you have to think about what you should do under your other powers and duties. I'm paraphrasing, but that's how I interpret it. So in this context, it would be saying, if you need to safeguard this person by providing services under Section 18, then that's what you have to inquire into and think about doing. So it's not creating new accommodation duties.
Thanks very much.
If I may, the question about failed asylum seekers getting support under the Care Act, the answer to that is yes, almost yes, but subject to Schedule 3 of the 2002 Act. So to the bare minimum necessary to avoid a breach of their human rights, which will often be not very much, unfortunately.
Thanks very much for adding that.
That's helpful. Thank you very much. We've just got to the end of our time. I'd like to say thank you to everyone for attending, and a huge thank you to all the speakers for their very well informed and detailed update. I certainly feel a lot better informed about adult social care, having heard had the benefit of their presentations. Thank you very much, everyone.